you all for doing Law Ki Padhai together. So for today, let's discuss about the question of law. In my yesterday's video, I discussed about the question of fact, okay, which the judges has to consider before deciding any case. So for today, we'll discuss about the question of law. One thing which I forgot to tell you in my yesterday's video about the question of fact was that the facts are basically classified under two heads, primary facts and secondary facts, okay. Primary facts are those which are proved using the evidence, okay. When we give the evidence in front of the court and when those evidence are used to prove or disprove a fact, those are primary facts, okay. And the secondary facts are those which are inferred from the primary facts. So, today let's discuss about the question of law and judicial discretion, okay. Yesterday I told you that I'll be discussing this today. So, before moving ahead, I would like to wish all the mothers a very happy Mother's Day. Stay safe, stay healthy, and may God give you a long life, a healthy life, a very happy life to you. Please take care of yourselves, okay? So now, let's move ahead. Question of law. Now, question of law can be well understood under the three heads: already established laws, second is no statutory enactment, and the third is judicial discretion. Let's study about this thing first. Already established laws. When any matter comes in front of the court, here the court decides the matter on the basis of the circumstance, okay, and the court is supposed to think. The court has to apply its judicial mind. The court has to think as to which law has to be applied on that particular matter, okay. This is the question of law. So let's take an example. Let's suppose a child under the age of say 7, under the age of 7 has committed an offence. Now, under section 82 of the Indian Penal Code, it has been said that if any child under the age of 7 commits an offence, he will not be held liable of that offence, okay. He will not be considered guilty, okay. Now, the court will apply this law on the situation and the court will see whether the child is above 7 years of age or the child is below that age, okay. If the child is below that age, he will not be considered as an offender, as a culprit. And if the child is above 7 years of age but below 12 years of age, then as per section 83 of the Indian Penal Code, the court has to look into the mind of the child. The court has to see whether the child was capable of understanding that offence or not, and on the basis of that the court would decide whether the child was guilty of the offence or not. Now here there is an established law and the court is applying that law on the situation, on the facts of the case, and after that the court will decide the case, okay. So here the question of law is whether to consider the child guilty of the offence or not. Already established laws. Now, no statutory enactment. There are cases where the case is there in front of the court and the court has to decide a particular case which has not yet decided before, which hasn't been decided before. For example, you can take an example of I'll tell you the case. I really want you to understand the case over here. The case is Mahendranath Pathak. Mahendranath Pathak versus and others, AIR 1970 and Assam 32. This is the case, okay, and I'll discuss this case with you. This case came in front of the court of Assam, okay, and under this case there was a question of law whether the sand is being considered as a forest produce or not under section 3 subclause 4 of Assam's Forest Act, okay. This was the case which the court has to decide for the first time. There was no rules regarding that, okay. So the court was supposed to decide this matter for the first time in the case Mahendra Nath Pathak versus State of Assam and others, AIR 1970, okay. So here, so in such cases where there is no statutory enactment, the court has to apply its judicial mind and they have to decide the cases. Now, the judicial discretion. The question of law as per judicial discretion is what? Where the judiciary, where the judges applies their own discretionary power. Okay, they have got their freedoms, they have got their rights, but they also have some limitations upon them. They cannot abuse their rights. So they have got some rights and duties to apply their discretion wherever necessary. And for example, let's take an example for this. If the question is of reasonable prosecution in a suit for malicious malicious prosecution, then it is decided by the judges. Although it is a question of fact, but still it is decided by the judges. Why? Because they have got their discretion. Okay. So, in case of any doubts, please feel free to reach out to me in the comment section and I'll be more than happy to help you. I hope that the concept regarding the question of law is clear to you. Question of law means that the court has to look into the matter from the legal perspective, legal point of view. They have to apply their judicial mind. They have to look into the law. They have to look into the facts of the case. They have to look whether there is a law or not, whether the law can be applied as it is or whether it requires changes and then we need to apply it, and so on and so forth. So this is basically the concept of the question of law. Tomorrow we'll discuss about the mixed question of law and fact. Okay. Till then, please take care, and in case of any doubt, any question, please feel free to reach out to me in the comment section and I'll be more than happy to help you all. Okay. So take care and study hard. Ask me doubts. Take care. Bye-bye. Thank you so much.